So if Heppner didn't answer the question of attorney AI use and privilege, where does that leave us? The answer is in genuinely unsettled territory. The email analogy is instructive. I remember this well because this is exactly when I became a licensed attorney. In the late 1990s and early 2000s, there was a real and serious debate in the bar about whether attorney-client communications conducted by email were privileged. The concern was that email passed through third-party servers, that ISPs had technical access to the content, and that this third-party transmission might constitute a disclosure that waived privilege. Legitimate concern. State bars issued ethics opinions, the ABA weighed in, and eventually the profession reached a working consensus. Email communication between attorney and client is privileged, assuming basic security precautions, because the attorney and client have a reasonable expectation of confidentiality in email, even though it passes through third-party infrastructure. Now, the AI privilege debate is tracking the same trajectory. The question is whether inputting client confidential information into an AI tool constitutes a disclosure to a third party that breaks privilege. And the answer, like the email answer, is going to be fact-specific and product-specific rather than categorical. Individual paid subscription tiers like the Claude Pro subscription with the training turned off are better than the free tier, but they're not equivalent to an enterprise agreement with a data processing addendum. Training being turned off addresses one concern, that your inputs could be used to train the model and thus become more broadly accessible, but it does not address whether Anthropic employees or systems can access conversations, what happens in response to legal process directed to Anthropic, or whether a court would treat the paid individual tier as creating a sufficient expectation of confidentiality for privilege purposes. Now, because I'm a total nerd about this and curious, I actually had a conversation with Claude itself about the Pro subscription in the context of my practice. Claude's response was telling. Its conclusion, which I found quite useful, was essentially training being turned off helps, but does not change the recommendation dramatically, and the placeholder approach for client identifying information remains the cleanest solution. Claude Pro itself said not to trust it, not to break privilege. Okay, if you want the full attorney-level analysis of Heppner and the complete picture of attorney AI ethics obligations, that's in this week's companion podcast episode. You can find it at Spellbinding IP on your favorite podcast platform, and I'll put a link in the description. This information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney. This episode may contain attorney advertising material. Law firm address and other contact information is in the show notes and bio and available at kingpatentlaw.com.